For years, college campuses across the country have been slammed for their handling of sexual assault cases. Rape victims say schools discouraged them from filing sexual assault complaints, delayed investigations, and allowed the alleged rapists to remain on campus and move freely. As bad as those claims are, the accused say schools may be even worse at protecting their rights. Joining me to talk about the issue are criminal defense attorney Dominic Lombardo and San Diego State University lecturer and sex crimes prosecutor Wendy Patrick. Dominic, let's start with you. You've sued San Diego State on behalf of a client by the name of Francisco Sousa, who was accused in December of sexual misconduct against a fellow student. You say his due process rights were violated. How so?
Well, I believe they are being violated. The proceeding still continues. As you know, the Office of the District Attorney declined to prosecute Francisco. However, the university is not beholden to that determination, and they have initiated their own proceeding. I believe that the university has not taken adequate steps to ensure that Francisco's rights are safeguarded. And specifically, I'm talking about the failure to provide any of the information underlying the allegation. I have no witness statements, no reports, none of the information that I would need to clear his name.
But isn't the university obligated to turn that information over to you?
Oh, absolutely. In fact, it was promised to me on December 18th. The following day, December 19th, that promise was retracted. Here we are 3.5, 4 months later. I still haven't received the information.
But according to the university's policy, when they conduct investigations like this, they do turn over that information.
It's true. The university takes the position that when the Title IX investigation is completed, a report will be provided to me that will include a summary of the allegation and the findings of fact, conclusions of law made by the Title IX Deputy Director. That's what I will get. I will not get all the witness statements or the information that she relied upon. Then a hearing will be conducted where that report is submitted into evidence. It's my position and firm belief that that rigs the process, because that report will be submitted into evidence without me having any opportunity to challenge the finding of facts before that's entered into evidence. We are left with an empty formality. And the hearing officer, I think, it's fanciful to think that the hearing officer won't adopt the Title IX findings made by the investigator.
Wendy, when there's been a sexual assault on campus, there are two tracks of investigations. There's the criminal justice system, and in this case, the DA's office decided not to pursue a case against Francisco Sousa. But there's also a campus investigation that could lead to an expulsion. What is the standard of proof for that investigation?
That's a great question. I'm glad we're talking about this because there's a lot of confusion about what happens after a campus sexual assault is reported. There's a disciplinary investigation if it is something that is just kept in-house. That is very different from a criminal investigation. The burden of proof in criminal court is proof beyond a reasonable doubt. That's a very high standard. That is not the burden of proof on campus, and there's been much made of the yes means yes law that we enacted this year. That really applies to college campuses. It amends the education code, not the penal code. The standard of proof there is preponderance of the evidence, which is much lower. Now, some cases go both routes. So they are investigated on college campus itself, and it's also investigated criminally in criminal court. But there's not only a difference in the burden of proof, there's a difference in the method of investigation. There's a difference in the way the parties are treated, both the accused and the victim. And there are also different rules regarding confidentiality. That is really important because we all know that sexual assault remains one of the most underreported crimes in the world, especially on college campuses. When you talk about confidentiality, that's going to even be more reason that some people choose not to report it criminally.
Okay, well, I want to let Dominic jump in here. Sexual assault is a crime. It's not a mere campus violation. Are campuses equipped to investigate a crime like this?
I think they could be equipped to deal with it if they paid more attention to how to do it properly. I think the criminal courts, the criminal justice model is instructive in these situations. Lawyers play a very meaningful role in the criminal courts, obviously. The standard of proof is different, as Wendy said. We have trials to a jury, but we do have very basic procedural elements there that I think can be adopted readily by the universities. Number one, I think a right to an attorney and Wendy may agree, is essential to vindicating the rights of an accused. And if the complaining witness wants an attorney present, it could be beneficial to that person as well. Secondly, an exchange of information, the very basic documents that the accused would need to defend himself or herself. That's elementary, and I think it should be provided early in the process as it is in the criminal courts. This is a change that the university could adopt quickly.
And we've got to close it there. Dominique, Wendy, thank you so much for coming on the program.
Thank you for having us.
Thank you for having us.